So my name is Neil McKeeja. I'm a 1L at Harvard Law School. I have the pleasure of introducing our moderator for the first panel, who is Justice Michael Cherry from the Supreme Court of Nevada. Justice Cherry began his career as a deputy, as a public defender, deputy Clark County public defender in Nevada, and he worked at the law firms of Manos and Cherry, and later Cherry, Bayless, and Kellisis. In 1981, he gained nationwide recognition for his work as special master of the MGM Grand Hotel fire litigation, and in 1983 as special master of the Las Vegas Hilton fire litigation. And a lot of the work he's done since then has been incorporated into mass disaster litigation around the country. He served as alternate municipal judge for the cities of Las Vegas and Henderson, as well as a justice of the small claims referee for Clark County. In 1994, he was an instructor at the University of Phoenix, and in 1997, he was named to head the newly created Clark County Special Public Defender's Office to handle homicide cases. There he led a staff of 6 attorneys and served in that capacity until being elected to Department 17 of the 8th Judicial District Court in November 1998. One of the main reasons that Justice Cherry is serving as moderator today is he chairs the Indigent Defense Commission, which is working to examine how the justice system deals with criminal defendants who can't hire their own attorneys. And everybody was at the keynote yesterday evening where Professor Bright talked to us about a system where the judges acknowledge that there's no real representation. The defense attorneys acknowledge it, the prosecutors acknowledge it, but nobody does something about it. And here we have someone who's actually doing something about it. And I'm pleased to introduce to you Judge Michael Cherry. Thank you.
Well, good morning, everybody. I guess the party wasn't that great last night, huh? Yeah. Although law students are used to getting up early and going to bed late. I grew up in St. Louis, Missouri, and went to high school, and then I went to the University of Missouri, and then I went on to Washington University Law School in the late 60s. And Washington University Law School is a top 25 law school, and I keep on reminding my colleagues on the court of that. But also, we called Washington U the Harvard of the Midwest, but we never figured out what the Washington U of the East is. So maybe somebody from the East can help me as to. In 8th grade, I used to play basketball on Saturdays, and I'd go home Saturday night and watch a thing called Perry Mason. I don't think any of you can remember Raymond Burr. You're too young. But here was a criminal lawyer who won every case. He kept on beating up a DA named Hamilton Berger. His clients would be exonerated every Saturday night. Either somebody on the stand would admit they did the killing, or somebody in the gallery would stand up and say, "I did it." And I said, you know what, that's what I want to do the rest of my life. But more importantly, I want to have a secretary that looks just like Della Street. I was smart enough when I went to the University of Missouri to go into advanced ROTC. So I was a second lieutenant when I graduated from Missouri, and then when I said to the Air Force, can I go to law school? And they said, oh, of course, Lieutenant Cherry. And 18 months into law school, I got a letter saying I was a first lieutenant. I said, oh my God, this is a great thing. So meanwhile, everybody else was scrambling from Washington U Law School to either go in the reserves to Canada or to Vietnam. I was lucky enough to not have to worry about it, and could enjoy my 3 horrible years of law school after 4 magnificent years at one of the best place schools in the country, University of Missouri. When I got out of law school, I got a phone call from the Air Force saying, you know what, we don't need you anymore, you've got a bad back, we've got a thing called the retired reserve. When you have a later political career, you can tell everybody you were an Air Force officer, because I was. And at that time, I was married and had a little girl who was 6 months old, and she's now 43. And we decided to pack up and move to Las Vegas. And my dream came true. I became a Clark County public defender. And in those days, there were 9 of us, all guys. And right away, it was doing felony cases. Oh my God, I thought I died and went to heaven. My first year that I tried cases, I had 2 not guilties and 2 mistrials, and I thought, this is great. The next 3 years, I couldn't even win a case, couldn't even buy a win. Finally was able to start getting on the winning track again. And meanwhile, I progressed in the public defender's office to become assistant public defender. So we started out with 9 fellas, then we went to 25 fellas when I was the assistant. I interviewed the first woman that was ever hired by the public defender's office, and unfortunately I left before they hired her. But today, the Clark County Public Defender's Office, which is Las Vegas, has over 100 attorneys and many, many women, minorities. It's well representative of the entire community. I then went into private practice for 20 years and still love doing criminal law. You heard about my exploits in mass tort litigation. I was a criminal lawyer that also was able to do mass tort litigation. That brought in the bucks. But in private practice, I was a court-appointed attorney for the county. I was a contract attorney for the county, which means I was in 3 courtrooms and would represent criminal defendants. And I was on the federal CJA panel, which I love because those type cases were really, really interesting. Plus, they had a thing called interim billing, where you could bill 2/3, and then at the end you got your 1/3. So you had the living expenses for the first part of the representation, and then the last part was found money because you didn't have to do any work for the last third. After 20 years in private practice, I had it. I was tired of chasing the almighty dollar, and on openings, they created a new office called the Special Public Defender. And that was when you can do only homicide cases. And I thought, this is great. Here I go again. So I applied and I got it. I had 6 attorneys work with me. I had 2 investigators. I got a retired FBI agent and a former parole and probation officer. They were my mitigation specialists, and had 3 clericals. And we really kicked ass and took names. We really did in homicide, because they weren't used to somebody coming in. At one time, we were in 3 separate capital murder trials. 6 of us were in trial. 1 guy was in LA because his uncle was sick. But we weren't afraid to try cases, and we got positive results by trying these cases. I would still be the special public defender today, but our legislature created 3 new departments in Clark County, 17, 18, and 19. I wanted Department 18 because I'm Jewish and 18 is life high, but my best friend Nancy Seda had 18. So I did what any Jewish fellow would do. I called the rabbi. I said, Rabbi, I can't have Department 18. What's 17? He said, high minus 1. So I was in Department 17, and I had 8 years of being on the district court bench. My first 2 years I did nothing but civil, and I was, like a pain in the ass to everybody. But the next 6 years on the bench, I did half and half civil, half criminal. And all I was polite. My first evaluation of being a judge on the district court bench was, this guy was an asshole when he was an attorney. He was very aggressive, but you know what? He's a very polite judge. And I didn't know whether to take that as a compliment or what. But I was fair to criminal defendants. And I'm trying to be somewhat positive. I know Steve Bright, painted the dark side, and I think Elizabeth would probably paint even a darker side. Maybe Jeff should be, and Sajel and Jim maybe will be a little more positive about the criminal practice. But when they did the chain gangs where they'd come into the court chained up, it wasn't all African Americans. It was a variety of types of peoples: Caucasians, Hispanics, Asians. In Las Vegas, it's a melting pot. So we'd have these folks, and they'd come in, and I'd be fair. I sent as many to prison as any of my colleagues on the bench. There was like 19 of us at that time. Now there's 52 judges in Clark County now. There were 6 when I started, 52. But when they'd come out, they'd say things like, "We love you, Judge Cherry." And I'd say, "Oh my God, if people get a hold of this, I'll never get reelected." So I said to them, we don't really need to say that. I'm trying to be fair. I'm firm but fair. So then they decided, they got together in the jail when they'd come over, and they'd walk by and they'd say, "You know how we feel, Judge Cherry." But all I was polite. I still had to hammer a bunch of people. I was on the bench for 8 years, and the Chief Justice retired, and I decided, you know what, let me have a go at it. I had won 2 elections. Only my first election was contested, and now all the people that I was in the contested race with, the 2 ladies are family court judges, and the fellow that I beat 55 to 45% is a federal judge, and he and I became very close friends. He was also appointed to the district court bench, so we served together for a while. But it gave me a real good insight. Having been in the trenches, like some of you are going to do, then being on the bench, you really get an idea what this is all about. But I decided, now let me see how the appellate side of this works. And we don't have a court of appeals. We're the busiest appellate court in the country. And because we don't have a court of appeals, each of us have 2 law clerks, and we have a staff of 30 attorneys that are our staff lawyers. 15 are criminal and 15 are civil. So a lot of things are done, if you read some of our opinions, they're usually done by us. A lot of the unpublished orders, which now are on our website, a lot of them are done by our staff. I got appointed to the Indigent Defense Commission. I only have a short period of time. I'm going to take an extra 2 minutes. The Chief Justice at the time was Bill Moffett. He and I were public defenders together. There was real problems in Clark County and in the rest of the state with indigent defense. There was a guy named Roberto Miranda. He was on death row for 14 years. They did an extensive investigation in the federal court. He was not only not guilty, he was innocent, completely innocent, after being on death row for 14 years. That cost our county $5 million. Also, there was an expose from our newspaper that said that contract attorneys, those who were working in the courtrooms, were the good old boy system. So we decided, you know what? We're going to take that away from the judges and establish an office of conflict attorneys. We did that in Las Vegas and in Reno, the big metropolitan areas. And so now the judges really don't have anything to do with appointments. We couldn't do it in the rurals because there's nobody else to do it in the rurals, and the rurals don't have, they have 15 judges in the entire rurals for like 300,000 people. And they have to beg attorneys to take cases in the rurals. So we started the Office of Conflict Attorneys. But where I made my bones as chairman of the Indigent Defense Commission is we were one of the first jurisdictions in this country to pass performance standards so that a person who's a public defender can look at these performance standards and know what they should do and what they shouldn't do. And we've got national recognition for that. I won an award from the National Association of Criminal Defense Lawyers. I'm the first judge in the history of that organization to ever win an award, and it was nice. They came to Las Vegas and they gave me a nice plaque. But I was glad I was able to do this because my colleagues let me do it. And when the Indigent Defense Commission came up with ideas, my colleagues went along with it. Now we're taking on the task of caseload standards. And Steve Bright talked about the caseload standards, where people have 300 felony cases or 400 felony cases, when the ABA says you'd only have 150. So that's it. I've gotten the word to stop, and now pass it on to Ms. Zota. We're passing on to Jeff, the public defender from San Francisco.
Well, good morning, everybody. I'm absolutely thrilled to be here with all of you. Amongst your ranks are the future. It'll be the future of the legal profession, and in a really real sense, the future of a lot of the hopes and dreams, things that we're working towards in our career and have not been able to achieve or accomplish. With the fact that 50 years has gone by, I mean, not even that, I mean, the Sixth Amendment has been on the books for over 200 years, and yet we're still fighting for such a basic right, the basic right to a lawyer. What Stephen Bright said yesterday, I wish I could tell you that was the exception. Aberration, something out of the Twilight Zone, but it's not. You can go to any court, anywhere in this country, and you will see people getting screwed. It happens all the time. And I wish I could say it's because we don't have enough lawyers, but we do have a lot of lawyers, particularly in California. But we don't have enough lawyers who care, who give a damn. And that's where you come in. That's where you make a difference. I was asked to talk a little bit about the history of criminal defense. You all know the story of Clarence Earl Gideon. And this is our Apple version poster of our constitutional hero and what he did. And it's an amazing story about how one person can make a difference, not even a lawyer. He would have been considered a three-striker by today's standards. Yet he took a stand and he changed legal history forever. In California, we've had public defender offices. The first one was in Los Angeles in 1914. Now, how is that? 50 years before Gideon, how could that happen? Our office, the San Francisco Public Defender's Office, was created in 1921. How did that happen? Again, one person. Her name was Clara Foltz. She was a single, divorced mother of 5, no education, lived in San Jose. She decided one day that she was going to become a lawyer. Only one problem. Women were not eligible to become members of the state bar. That was the law. So she apprenticed for a lawyer, learned the law, and advocated to change the law, which she did. And she did a brilliant thing. The law then said, right on the books, that only white males could become members of the state bar. Well, she changed white males to person. Not only did that allow women to become attorneys, but also people of color. One person, she did that. There was another problem, though. She didn't have a legal education, and law schools wouldn't admit women. So she applied at Hastings, showed up. They didn't realize she was a woman. They thought that she had enrolled her husband. And they ejected her from Hastings. That's where I went to school, my alma mater. And this was in 1870. And so she turned around and sued Hastings. The case went all the way to California Supreme Court, and she won. And she got into Hastings. She was the first woman attorney in California. Of course, she couldn't get a job. So what do you think she did? She went out, became a criminal defense attorney. And think about it then. There were no women on juries, no female judges. It was an all-male world. And she began representing clients in court. And there's a great book that's written by Professor Babcock from Stanford here called The Woman Lawyer. And you got to read some of the transcripts of those trials, because she would regularly dice and slice her male opponents who would attack her for being a woman. Attack her for being a woman. Openly. That's what they would argue. And she became a very well-known criminal defense attorney, routinely beating her male counterparts. And in the 1880s, she began writing about the concept of a public defender. I think she coined the term, because there were no public defenders. There was no free lawyer. And she introduced the concept in a paper at the Chicago World's Fair in 1893. She had to spend 27 years advocating throughout all the western states for public defenders. Can you imagine that? I couldn't. I could not imagine spending over 2 decades. Of course, she did other things, but I couldn't imagine that. And yet she did that. And in 1921, the Foltz bill passed. The Los Angeles Public Defender's Office has already been in existence for about 6 years, but that's how we got public defender offices in California and in other western states. So it's from that really proud legacy that we celebrate this right to counsel, this very basic right that we all have. Public defender offices today, how are they different? What would Clara Foltz think of where we are as a society? And it really takes, I think, a change in the mindset to imagine how it could be different. I recently met the public defender. He's sort of the person in charge of indigent defense in the UK. And I said, well, you know, how do you provide indigent defense in the UK? He says, well, the way that we look at it is that anyone should be able to get the same quality of representation of a person, you know, who has money. So, well, how do you do that? Well, they can just go to whatever law firm they want and ask the lawyer to represent them, and if the lawyer agrees, then we pay for it. I said, wow. I said, I could go to Morrison Forrester and just ask for Jim Brosnahan, and, you know. He said, yeah. I said, that must cost a lot of money. He said, yeah, it's very, very, very expensive. It's about, he gave me a number, it was like over $1 billion. And I said, well, how does that compare to what the prosecutors get? He said, well, it's about 3 times less. I mean, 3 times more than what the prosecutors. It's a 3-to-1 ratio. And it was unfathomable to me that that was possible. And I said, well, what do people say about it? Oh, people are always complaining that it costs too much, but it's just a cost of providing equal justice. And I never forget that, because it doesn't have to be the way that we do things in this country. It doesn't have to be that public defender offices are so severely underfunded. In this country right now, there are public defenders, and Justice Cherry mentioned this, that are handling 500 felony cases at a time. I don't care how great of a lawyer you are. Right? These are all great lawyers here. It doesn't matter. If you got that many cases, there's no way that you can do a good job. When I started at the public defender's office in 1985, the caseload for me as a misdemeanor attorney was 300 cases per lawyer. I mean, think about that. Take everyone in this room and multiply it by 2. That's your client caseload. You can't even keep track of who your clients are. It's like working at McDonald's, except you don't know who wants mustard or who wants cheese on the hamburger. You can't keep track. And we did the best we could. I never worked as hard in my life. We used to go to work at 6 in the morning, get off at 10 or 10:30 at night, and we worked 6-7 days a week. It was just the reality. And it was a great experience. I tried 28 jury trials in the first 18 months I was in that office to verdict. But you have to pick and choose. I'd have to say, I like you, I do a good job on your case, and I'm sorry I can't do a good job. It's a crime to practice law in that way. And so one of the first things that I did when I was elected public defender is to put caseload standards in place. And it was a huge fight, because what happens as public defender is that you have to advocate for the resources, and the politicians, the elected officials, we're not real high on their priority list. And so what happens is that your budget is always the first to get cut. Currently now, about 10 cents is spent for every dollar that's spent on criminal justice for indigent defense. 10 cents. Not a lot of money. The district attorney's budget is about $40 million. My budget is $26 million. Now, it's true that they have more responsibility than we do in terms of, they represent the state in retained cases and conflict cases, but still, nonetheless, it comes down to resources. If you have the resources to do the job, you can do a good job. And so what we've done is that we've implemented caseload standards. So my misdemeanor attorneys, they still handle 70 cases, which is a lot of cases, but not 300. My felony attorneys handle caseloads about 30 to 40. And beyond that, public defender offices play a much larger role. We have a full-service expungement program. We expunge over 2,000 records a year. We have a full-service juvenile unit with social workers. I have now 20 social workers. When I started in the office, we had 1 paralegal for 82 attorneys. Now we have 20 for 92 attorneys. And so it's still a battle. It's still constantly a battle, but we're getting to that place where, as a public defender office now, we are providing holistic representation, which is, I think, the goal of where we want to be. So we can treat every client, whether you're charged with a misdemeanor or murder, and provide them with the very best possible representation.
Elizabeth next. Elizabeth, talk to us about the death penalty.
Right.
Got to give us a little bit of positive.
Yeah, I know.
Promise me a little bit of positive.
So I'm Elizabeth Semmel. I'm on the faculty at Berkeley Law, where I direct the death penalty clinic. Actually, Justice Cherry asked me as we were coming over whether or not I was going to be gloom and doom, whether or not I might be able to, inject a ray of sunlight into my conversation with you this morning, and I looked at him emphatically and said no. But I'm going to start with something that I think is peculiarly positive, which is that I believe that the odds are greater that we will end the death penalty in the United States, greater that we will do that than that we will provide quality representation to the men and women facing capital punishment. There is nothing mysterious or magical, and my job here is to talk to you about representation in the context of capital cases. There is nothing mysterious or magical about how to represent a defendant effectively in a capital case. That formula was spelled out in the American Bar Association's guidelines for the appointment and performance of counsel in death penalty cases in 1989 and decades earlier in standards the ABA promulgated on behalf of the defense function. The ABA guidelines, notwithstanding the comments of some who've argued that the ABA guidelines are all about lining the pockets of lawyers, the ABA guidelines were adopted for the benefit of defense, not for the benefit of defense counsel, but to ensure that men and women who face the ultimate punishment receive, in the words of the guidelines, high-quality representation. And the guidelines simply set out what lawyers must do to represent their clients. The guidelines, which I want to talk about for just a minute because they really are the definition of effective representation, require, as Steve said last night and Justice Cherry said this morning, they require an independent appointing authority that untethers lawyers from judges so that they can act truly in the interest of their client. The guidelines require that 2 lawyers be appointed and that they be appointed and qualified, as that term is understood both in terms of skill and experience. The guidelines require that lawyers be compensated at fair market rates to ensure that not just the lawyer who is desperate to be appointed by a judge to whom he is beholden, but actually a lawyer who is experienced and skilled will do this work. And the guidelines require a team approach to capital representation, a team of experts and investigators. And the guidelines are intended to serve that singular objective of benefiting the clients. Now, the fact that the life of a man or a woman is on the line ought to compel this response from the court. Surely, when a man or a woman's life is on the line, there ought to be resources, as Jeff was saying a moment ago, there ought to be resources that match the type of resources that are provided to the state prosecutors, to the prosecutors in general. Those burn grants, those LEAA grants, as they used to be, in the millions and billions of dollars, which go to the prosecution not just for training, which is the only money that defense lawyers get from the federal government, but for actual representation in criminal cases. But if this had been the response from the courts, if ever there was a time when it was necessary to provide competent representation, if that had been the response from the courts, courts would not tolerate sleeping lawyers, they would not tolerate drunk lawyers, they would not tolerate lawyers who miss deadlines and the client pays the penalty for the missed deadlines with his life. The court would not tolerate what was condemned in 1932 in Powell versus Alabama, which, as you all know, is the precursor to Gideon. Courts would not tolerate lawyers who make no attempt to investigate. Courts would not tolerate, as the court said in Powell, lawyers who are pro forma rather than zealous. If life or death compelled the type of response that I'm talking about, Justice Ginsburg would not have said, as she did several years ago, the following: I have yet to see a death case among the dozens coming to the Supreme Court on eve of execution stay applications in which the defendant was well represented at trial. Overwhelmingly, in those cases that Justice Ginsburg was referring to, overwhelmingly, it wasn't just that relief was denied, review was denied, and those men and women were executed. If life or death compelled the type of response that I'm describing, the court would not have said in 1991 in Coleman versus Thompson that when a lawyer misses a filing deadline by a day, failing to file a notice of appeal from post-conviction review, and this was a major law firm that missed that deadline by a day, the court would not have said that the client pays for that failure with his life. If the death penalty compelled the type of response that I'm talking about, it would not have taken the Supreme Court of the United States until 2000, that is 25 years after Furman versus Georgia, to, for the first time in a capital case, say that lawyers performed deficiently, that a lawyer's ineffective representation warranted reversal of the conviction. That is 25 years. 25 years for the United States Supreme Court to acknowledge the ABA standards for the defense function that I've been talking about. It would not have taken another 3 years in Williams versus Taylor for the United States Supreme Court to acknowledge the ABA guidelines that I've been talking about, which for the first time the court referred to as guides for assessing, for determining what is reasonable performance in a capital case. And it would have not have taken, or I should say this, it would not have been in 2009, just 6 years after the court finally acknowledged the ABA guidelines, that in a case called Bobby versus Van Hook, the United States Supreme Court took a step back and said, well, wait a minute. The guidelines are standards set by a private organization. The court is not beholden to guidelines set by a private organization. And the court, actually it was Justice Alioto in a concurring opinion, Justice Alioto in that same case wrote that the guidelines, these ABA guidelines, these guidelines that we've referred to as the standards for determining what is reasonable, Justice Alito would not have written that the guidelines have no particular relevance in determining whether a lawyer has provided constitutionally adequate representation. You know, in 1987 in McCleskey versus Kemp, a case that I'm sure most of you are familiar with, where the court ruled that Mr. McCleskey's evidence of pervasive racial discrimination in the state of Georgia in the application of the death penalty, that his evidence was not sufficient to show selective prosecution on behalf of the government. In response to that ruling, that majority ruling, Justice Brennan wrote that the court's treatment of Mr. McCleskey's evidence, of his overwhelming evidence of discrimination, was the fear of too much justice. And I would say to you that when the court stepped back from the guidelines in 2009, because the court recognized that the application, the fulsome application of these guidelines to the representation of our clients was indeed the fear of too much justice. The fear of exposing the very kinds of errors, the very kinds of indignities, and the very kinds of injustices that are so pervasive in the capital punishment system. So, it's important to understand that when the United States Supreme Court in 2009 broke off its very brief engagement with the ABA guidelines, that has had a ripple effect. And a ripple effect even in the state of California. In 2004, I think it was, the California Supreme Court issued one of its rare death penalty reversals. Now, you might be surprised that death penalty reversals in the state of California are rare. But it's important to understand that the California Supreme Court affirms 95% of all capital convictions on direct appeal. It affirms 98% of all capital convictions and sentences on habeas corpus. The affirmance rates in states that we often like to diss, right? States like Georgia, Texas, Florida, Alabama, states in the Deep South. The affirmance rate in those states is between 50%, is about 50% or lower. So the California Supreme Court is high, very high on the scale of courts that affirm capital convictions and death sentences. And so in 2004, the court issued its very, very rare reversal in the case called Lucas. That was in 2004 for ineffective assistance of counsel. This year, in a case called Reno, the California Supreme Court stepped back from the guidelines and said the ABA guidelines, which we so heartily embraced in 2004, those guidelines are not congruent with the requirements of constitutional representation in a death penalty case. I find that I've somehow eaten up my 10 minutes. I've been entirely dark, gloomy. I think, however, not inappropriately so. What I was also due to talk about was what is it that we're doing in the death penalty clinic on at least one branch of the Underground Railroad to provide qualified representation to men and women, and the men and women we represent are almost exclusively in the South, who are facing capital punishment. So since I haven't had a chance to do that, I'm going to do that, I'm sure, when Justice Cherry asks me to give some remarks.
Absolutely. And also, when I was talking to the professor about the death penalty, and I said, don't be all doom and gloom, I started talking about some of my experiences where I still have two men on death row. I became doom and gloom, so thank you very much. Now, do we go to immigration or do we go to civil Gideon? Civil Gideon, Mr. Brosnahan.
Okay. Morning, everybody. I was sitting here looking at you and thinking you're all in law school, and I was remembering what I was thinking about. It seemed to me that America in the late 1950s needed to be reformed. Well, the good news on a bright note this morning is the previous generations have left for you a mess like you would not believe in the legal area. And when I say that, I always feel disloyal because I hear people say correctly, this is the greatest legal system in the world. Go to a July 4th talk, go to a Law Day talk, listen to some people, and they say this is the greatest legal system in the world. Well, I would like to address that for you for a moment. My name is Jim Brosnahan. I'm a trial lawyer at Morrison Forrester. Elizabeth, who you just listened to, was a public defender in Solano County. If you can do that and not give up, you are a very special person. I know anybody here from California may know Solano County. I noticed you moved out of Solano County. She would rather have cases in the South on the death penalty than be in Solano. No offense to anybody who's from that county. All right. It may seem powerful strange to you that there are only half the jobs in the legal community in 2013 to measure up to the full number of law students around the country at the present time. And while that is true, 6 out of 10 of the middle class who go to civil court go with no lawyer. And 8 out of 10 who are at the poverty level go to civil court with no lawyer. I have seen them. It is where I spend a lot of my time. I do civil cases, I do criminal cases, I do pro bono, and I'm proud to say I do money bono. All right. In our firm, you must do both. And they are the undead. They are like the movies. They walk and they ask. I've seen them. When you give percentages in this culture, you're basically providing the listener with an emotional protective gear. 6% of the people have this. 12% have this. Only 1% have this. 10 of the middle class go without a lawyer, and many of them are facing opponents with lawyers. For example, unlawful detainers in San Fernando Valley, which are being moved out because of the cuts in California. We may give you a special California point of view today, which is extreme because the legislature and the governor has taken away a large portion of the court's budget, which is a separate issue. But they're moving 13,000 unlawful detainers out of the valley, and whoever is going to appear in those cases, which, as you know, are cases where there's an effort by a landlord or an owner of property or a bank to get people out of their houses, out of their living quarters, which in many cases the next step is homelessness in America in 2013. 9 out of 10 of the defendants in unlawful detainer cases in most of California have no lawyer, and 9 out of 10 of the landlords who are bringing the action have a lawyer. I have been in the courts my whole professional life. I know what you have to do. You have to go to law school. You have to spot the issues. You'll have no trouble spotting these issues when you get out. Even before you get out, you'll see it right away. Now, I don't believe in saying to a new generation, all right, we mucked it up. There it is. You're supposed to fix it, you know. No, that's not right. Is there any hope in this? Yes. There is a whole group of dedicated lawyers. My friend of 45 years, Earl Johnson, has worked on this issue of civil representation for 45 years. He does not give up. When we were alone, I say, why don't you give up? He doesn't give up. The status quo, this I report to you on a very selfish, personal basis. Protecting the status quo is no fun at all. It's not as much fun as stepping out and saying, this is unacceptable. In the United States, in a legal system with a due process clause, that a person with a lawyer can be against a person without a lawyer who doesn't have a clue about evidence, procedure, appellate review. So what happens for the society and the culture? What happens? The problems of that enormous group of people, the legal problems, go unprotected, unaddressed, unappealed. It's not acceptable. Now, it's being studied, and it should be. Let me be clear. It should be studied. There are distinguished people, some of them at this university, at both. They are studying it. And I could not tell you how important that is. And I was on a panel when suddenly one of the panelists said she was studying whether lawyers do any good. And that was it. I lost it. You're not supposed to do that on a panel. You're supposed to be polite. I lost it. I said, wait a minute, excuse me. I'm a lawyer. I know what lawyers do. Lawyers do a lot of good. I see it every day, all day. What are you talking about? Well, I did a study of an administrative agency, and some had lawyers and some didn't. And I concluded something. I said, excuse me. I don't mean to be personal. But I'm thinking that maybe somebody should study your study to determine whether you are doing any good. I did. I said it. When I was your age, the issues I thought were race, poverty. Didn't know much about the legal system except it sounded like trial would be a lot of fun. And it turns out it is. Cross-examine people. It's really great. I recommend it. This issue does not enjoy, and perhaps we'll have time to get in this a little bit, does not enjoy the support that the Gideon movement had at the time that Gideon was passed. There had been several cases that had already been passed, enacted by the Supreme Court. For example, a federal court. They had the right to counsel. I am pre-Gideon. I'd rather say that than I'm 79 years old. I'm pre-Gideon, okay? And I was a federal prosecutor. And Lester Buatti stood here next to me because he had killed Alice Sicotti on the Navajo reservation in northern Arizona, and I was prosecuting him, and he had no lawyer. And the judge said, Mr. Beck. Now, Mr. Beck had come to argue a civil motion on law in motion, which was the same day. Mr. Beck, you represent Mr. Buatti. Mr. Beck was probably my age, although I felt he was younger. He was probably, as I was, 26. Came up and assumed the defense of Lester Buatti, who was borderline schizophrenic, hearing voices, killing Alice Sicotti, trying to kill her 10-year-old brother, and so forth, on the reservation. So I didn't think it was right. I thought it was wrong. Each of you will be out there, and there will be moments like that, and you'll hopefully act on it. You're already in this wonderful society. You'll act on it. And there'll be people who tell you right away, don't. So I went ex parte to Judge Ling, who's a federal judge, and I said, Judge, this is a heavy case. There was actually a death penalty, but I had no intent of asking for it. But there was a death penalty in the case. And I said, perhaps there should be a second lawyer. So the next appearance, Judge Ling said, Mr. Beck, would you like a second lawyer to help you on the case? He said, I don't need a lawyer, said Mr. Beck. I went back and I researched, what's going on here? This is not right. And there was a book issued by a New York group that talked about representation. It was in the early days. And that's when I realized that full representation in the United States has got a long way to go. And without it, to be a lawyer is like to engage in First Amendment. Every argument you make, every motion you make in a criminal case, every position you take on landlord-tenant, everything that you do has the potential to change the law, and the law always needs change. There are conservatives who believe they can hold on to the past and that the law is clear for everybody to see. They're in the Federalist Society. After the last 4 years of economic upheaval, maybe you want to change, I don't know. Being in the Federalist Society is never saying you're sorry. You're not sorry for free markets, and you're not sorry for the focus that you have. And where's the focus? Economically, you know where that focus is. And there is inadequate focus in this society. I'll leave you with this. On the bottom 60% of people in the United States. Will your generation meet that? Will you stand up and say, this isn't right? I am sure of it. I am sure of it. Thank you.
Now, Sejal Zota on the National Immigration Project. Talk to us about immigration and Padilla.
That is a very hard act to follow. Well, everyone's act is a hard act to follow, but I will say that I will play good cop to Elizabeth's bad cop, and I'm going to talk about some positive developments. Now, you've heard about Clarence Earl Gideon, who from his Florida jail cell wrote to the Supreme Court. And on this 50th anniversary of Gideon, I would like to tell you about Jose Padilla. Jose Padilla was someone who came to our country as a teenager from Honduras. He came as a permanent resident. He made the great state of California his home. He married a U.S. citizen, went on to have 3 U.S. citizen children, all of whom are disabled, all of whom he has cared for. He fought in the Vietnam War with honors, and he became a truck driver. And when he was driving his truck through Kentucky, he was arrested when police officers found a large amount of marijuana in his truck. And by this point, Jose Padilla was American in most senses of the word. He had been in the country for more than 30 years. The country for which he had fought. He had a wife, kids, a life here. This was his only home. But his attorney said, you should plead guilty to the charges. It won't affect your immigration status because you've been here for so long. And so like most criminal defendants, he did what his criminal defense attorney told him to do. He pleaded guilty. But his criminal defense attorney could not have been more wrong. The plea subjected him to mandatory deportation. And when I say mandatory, I mean the judge who would go on to order him deported could do nothing to stop it. He had no discretion to consider his military service, his disabled children, all his contributions to the community. And his plea also subjected him to mandatory detention. So after spending time in jail for the criminal case, he was going to sit in another prison for an unlimited period of time while he fought his deportation charges. It also meant that once he was deported, he would never be able to come back to this country and see his family again. And so he, like Clarence Gideon, filed a pro se petition. That's how his case started. And like Clarence Gideon's, the Supreme Court took this case and granted his petition. And they said the Sixth Amendment requires defense counsel to provide advice, correct advice about the immigration consequences of a plea. Now, this didn't come out of nowhere. Many defense attorneys had been doing this for a long time. Good defense attorneys. They knew what was at stake for their clients. And so and the practice standards required it. You know, over time, the standards required more of attorneys, increased the obligations. And so in that sense, you know, Padilla just recognized the progression of that development. But in another sense, Padilla was startling because it went against what most of the lower courts had held. And it's incredibly significant that the Supreme Court recognized that for non-citizen defendants, this is an integral part, sometimes the most important part of the penalty when pleading guilty. This is what it's about for non-citizen defendants, and they recognize that it's a particularly severe penalty. And so in that sense, Padilla, you know, has gone a long way. It's made strides towards fulfilling Gideon's promise for non-citizen defendants in both the criminal context and the immigration context. That said, there's a lot of work to be done, and that's where my organization comes in and others. There's some attorneys that have been doing this for years. They've incorporated it in their practice, but there are many criminal defense attorneys who still are unaware of the significance that immigration consequences, that the plea can have on immigration consequences. And I think that defense attorneys, they can learn the basics, but immigration law, it is this beast. It is hyper-technical. It is only second to tax law in complexity. And it is constantly evolving. And so I think it's unrealistic to expect defense counsel to do this on their own. They need help. They need access to expert assistance. And in my organization, with others, we provide national and state level training for defender groups. We create resources, written resources, practice advisories on new cases. We really encourage that public defender offices like Jeff's, they have their own in-house immigration experts. And so, for example, in Kentucky, where all of this happened, in each of their 31 offices now, there is an in-house immigration expert that's advising the office. But again, that said, there's a lot of work to be done, a lack of resources, still a lack of buy-in. There's still attorneys who don't think that this is their job. And I hope that you, as future leaders, will be involved in the implementation of Padilla, that you will really help fulfill Gideon's promise in this area. I think Padilla is also a building block for the right to counsel in deportation proceedings. I'd like to tell you a little bit about a case, my colleague's case, on which I consulted. Alexander came to the U.S. from the Ukraine as a refugee, where he was fleeing persecution. And he made Portland his home with his wife and his 2 kids. Unfortunately, Alexander was diagnosed with paranoid schizophrenia and a severe case of depression. And so ultimately he ended up on the streets, and he was convicted of 2 assault offenses. And then he was put into removal proceedings. And when I say removal proceedings, these are matters where the government is forcibly trying to deport you. And when I say forcibly deport, I mean they literally put you on a plane in an orange jumpsuit and land you in a country in the middle of the night that you may have left as a child, where you don't speak the language. You arrive in the middle of the night, you may not have a dime in your pocket, and you may not know anyone. And you have to create a new life for yourself. And that is what is at stake in these cases. And then there's detention. Almost half of non-citizens are placed in detention. They call it detention, civil detention, it's jail, while these cases are pending. And for some people, it means years. For Alexander, he was detained for 2 years. And you're in a local jail somewhere that contracts with federal authorities, or you're in a mass immigration prison that contracts with federal authorities. And despite the fact that they put you in jail, they put restraints on you, they forcibly put you on a plane to a country where you don't want to go, this is considered civil. Removal proceedings are considered civil, and so there is no Sixth Amendment right to counsel. And the immigration statute, makes clear that any representation must not be at the cost to the government. So the only people who have attorneys are the folks who can afford it, or if you have the fortuity of finding pro bono counsel. And Alexander did not. He was unrepresented. And so he had to take on a U.S. trial attorney who's trained in immigration law, who was asking the immigration judge to deport him. These are very adversarial proceedings. They're also incredibly complex. I mean, federal judge after federal judge has recognized the labyrinth of immigration law and that you cannot navigate it without an attorney. And so Alexander told the judge, I don't understand the purpose of these proceedings. I don't understand why I'm here. I mean, he had actually been found mentally incompetent. And the judge ordered him deported anyway, didn't notify him about his right to appeal, and most importantly, didn't tell him that there's a way that you could actually stay here. You are eligible for immigration relief. And so it's startling that in the last 5 years, half of non-citizens have not been represented. I mean, it's shocking. And I think a clear case could be made for a constitutional right to counsel for non-citizens. I mean, it's the only way that you can meaningfully apply Gideon is if they have a right to counsel. And I just want to say, ultimately, Alexander, he was represented 2 years later, and he won his case. Counsel made the difference. And I think what Padilla does, if you could apply the Supreme Court test, I think already there's a great case to be made. But Padilla really heightens the case, and it demonstrates what a severe penalty deportation is. I mean, it's punitive, and the Supreme Court came close to saying that. And so I just want to say this is about fairness, about a fair shot, a fair shot at immigration court. To remain in the U.S. We know that counsel makes a difference, and we could talk about Supreme Court precedent, but I think the way that we get there is through the stories of immigrants who haven't gotten a fair shot, the stories of immigrants who are your neighbors, who are working and living in your communities, living the American dream, and that's what we've done in the past. In Padilla and St. Cyr, we've presented the court with the stories. And I would encourage all of you in your lawyering to do that and to focus on that, and you'll be surprised with how far it'll take you.
Well, I'm going to ask the panel some questions, and then you'll let me know when we're ready to go to the students for some questions. And we'll start with an immigration question. When I was a district court judge, we had our criminal judge meeting, and we had people from ICE come over, Immigration and Customs Enforcement, and we asked them about what type of offenses would be deportable. And guess what the answer was? The answer was, it depends. And also you talk about Kentucky. Well, what about the rest of the United States? I know that in Nevada, we don't have a lot of in-house immigration information, and a lot of people are getting shafted. Could you comment on both those issues of ICE and also of why Kentucky of all places? I'm sorry. I was conceived in Kentucky at Fort Knox, so I was bred in Kentucky.
Those are great questions. There are several grounds of deportation. There are many offenses that make you deportable. And I would say I think that drug offenses is the leading ground, the leading basis of deportation, and that's drug possession. We're hoping with immigration reform there may be a moment to change that, but it can be as minor as shoplifting. A first-time shoplifting with a suspended sentence of a year where you just do probation results in mandatory deportation.
One of the deals we've worked out with the Pardons Board in Nevada, where it's the 7 Supreme Court justices and the Attorney General and the Governor, that if somebody is illegal and they've got one of these mandatory minimum 10 to 25 after 5 years, we worked it out with ICE that they would be deported immediately, and we get all the conservatives in favor of it because of the financial ramifications, and then if they come back, the U.S. Attorney would prosecute them. So that's worked out pretty good because we get the conservatives to pardon a lot of folks and get them out of the prison system. Jeff, I'm going to ask you the next question on specialty courts. What about Gideon and drug court, DUI court, veterans court, mental health court? Is there Gideon? I mean, I know some states the DAs won't go into specialty courts and the PDs won't go in, and the people stand there by themselves. And sometimes they get punished and go to jail. Tell me about Gideon and San Francisco Public Defender's Office with specialty courts.
Well, most of you may have heard of collaborative courts, specialty courts, boutique courts. These are courts which are penned as problem-solving courts where individuals can go and get treatment. Drug court, for example, is usually a year or 2-year program where you engage in drug treatment, and in exchange, there's some benefit that's enters to you. It could be a dismissal of your case or a reduced charge. We also have a mental health court where individuals who suffer from severe mental illness and are charged with a criminal case can go to this court and get treatment, and again, in exchange for a reduced sentence or dismissal. In some cases, there are also what they call community courts, which are pre-plea courts, where a person is given an option to go to that court as a alternative to going to the criminal courts, and usually you do some form of community service. These courts, they do have their benefits. I think that in San Francisco we've been particularly diligent to ensure that people aren't required to plead guilty in order to participate in these courts. Often the prosecutors will say, yeah, we'll give you treatment, but you have to plead guilty. And the consequences of a criminal conviction are huge. A person who's convicted of a misdemeanor or moral turpitude can't qualify for public housing, can't qualify for public benefits, can't receive scholarships to public institutions. And so when you're talking about treatment in exchange for a plea, that's not something that I favor. I think that the other problem with these courts is they can sometimes become dragnets for cases that wouldn't otherwise be charged. That if a case isn't provable, then no matter how well-meaning the court or services are, the person shouldn't be required to participate. So it's sort of this dilemma between the legal outcome and the social outcome. And sure, we want to provide people positive social outcomes for their cases if somebody needs services, but you don't want to condition that on pleading guilty. You don't want to condition that on giving up your rights. If you have a right, and you know, this is something that it's important to mention, is that the right to a lawyer means that you have someone who presumably is going to stand up for you. Means that you're going to have somebody who's going to enforce your rights. But just because you have a lawyer doesn't mean that they're going to do that for you. Right? You have some lawyers who are like a potted plant. They stand there and do nothing. And lawyers, I think, I don't know if Jim agrees with this, exist to try cases, at least in our universe. And that if you don't try cases and you don't put the government to the test, you will never know objectively or even subjectively what the value of a case is. So when it comes to these collaborative courts, yes, I think they are a good thing. Yes, I think that there are good social and legal outcomes for people, but it's also a very dangerous thing because you can be sent to one of these courts and railroaded by people who are patting you on the back and telling you that they're doing this for your own good, when in fact the case against you isn't worth a dime.
Thank you. Now you learned I'm going to teach you a very valuable trial tactic with Elizabeth, because what happened was Elizabeth was about to say something, and let's pretend like you're a jury and there was an objection, and it was sustained, so she wasn't able to tell it. And now on redirect, I'm going to say, Elizabeth, what was that you wanted to tell the ladies and gentlemen of the jury?
Now, this was my opportunity to redeem myself by giving you something hopeful. And I think that the death penalty clinic at Berkeley, which I direct, and there are several, not many, but just a few of them around the country, are very hopeful opportunities for students. So it very quickly, what we do in the death penalty clinic is to represent men and women facing capital punishment at different stages of the proceedings, primarily in the South. And I could talk more about the inequities in California, of which there are many. I could talk more about why California, in many ways, is more like the South than it is different from the South. But the reality is that 85% of the executions in the United States occur in the South. And so the urgency and the deprivations in the South are fundamentally greater. And the students in the clinic who enroll for a year, all of our students are required to enroll for a year, really work shoulder to shoulder with the faculty and representing these individuals. And so just to give you, and the students are in the field, interviewing witnesses, interviewing jurors, in archives, getting records. They're writing motions, they're writing briefs, they're doing all the things that lawyers do, and frankly, a lot of the things that lawyers ought to be able to do better, but don't know how. And that is kind of the nitty-gritty of preparing a case for trial, which is meeting, interviewing, and spending time with witnesses. So they do all of that to help put these cases together. And so here's a bit of the good news. The clinic has had cases in addition to one client in California, Alabama, Georgia, Virginia, North Carolina, and Texas, and now Louisiana. And some of these are clients who we've represented since the clinic opened in 2001. And what the students learn is that when you make a commitment to a client in a case, in a capital case, especially in a post-conviction case, that it is an enduring commitment, that it is a sacred commitment until that case is over. But we've been successful in 4 cases that we were involved in Texas, in Virginia, in Alabama, in Georgia, in taking death off the table for the clients. And that's huge. And that was really and truly the nitty-gritty work of the students that I just described. The witness interviews, the finding the medical records. I mean, so much, we talk a lot, and I did, I think, unfortunately, disproportionately about the law and the decisions by the United States Supreme Court. These cases are about the facts. They are, as Sejal said, about the stories. That's what wins these cases. Particularly when you have a court like the United States Supreme Court and many other courts that are hostile to you when it comes to the issue of the law, you can oftentimes, what you must do is find the facts, tell the story, develop the compelling narrative. And that's what our students have been phenomenal at doing, and I think in this way prepares them so well for practice. The numbers of students who go into public interest practice from law schools like Berkeley is sadly few. And part of that, and you all know this better than I, is a function of the enormous financial burdens that you all carry. But 60% of the students in the death penalty clinic are now, who've graduated, are now in public interest practice. So I consider our mission in the clinic not only the vigorous representation of our clients, but also to be, as Justice Marshall said, drum majors for justice, in the sense that we sort of procreate, that we proselytize, for lack of a better word. I'm going to mix a lot of metaphors here, but that we inspire and help and facilitate and encourage and enable our students to go out and do the kind of work that Jim is talking about, that Sejal is talking about, that Jeff is talking about, whether in the civil or the criminal courts.
Can I ask Jim one last question? All right, Jim. I want to ask you this. I went to the Conference of Chief Justices, and Clark County, the county has just provided for representation of children by lawyers in the abuse and neglect segment of the family court. And I thought, gee, I'm real proud. Here I come as Associate Chief Justice at the time to the Conference of Chief Justices and tell the story. I was in the minority because a lot of the Chief Justices felt that to bring a lawyer into that setting to represent the child is wrong, and that you should just use guardian ad litems. Right. That goes against everything that you're talking about civil Gideon.
Right.
Comment on that.
And the atmosphere, and I have made a comparison between the pre-Gideon legal atmosphere, what was being said, what was being thought. You were coming out of a conformist period. You had the Warren Court. Criminal procedure was being repaired in a number of ways. Here, you would be amazed at the opposition to right to counsel. There are even some poverty lawyers, and they are perfectly logical. There are not a lot of them, but there's some who say we'd be swamped if there's a right to counsel. There's no provision for it. There's no infrastructure. You go back and look at Gideon and look at the brief that was filed at that time. All of those arguments were there at that time. Interestingly enough, in this great book by Anthony Lewis, who actually was in our class at law school, Gideon's Trumpet. This is a great read. I mean, this is a really good read about how you accomplish reform. I digress for a second to say, by the way, it wasn't the American Bar Association that said to the Supreme Court, you got to fix this. although they may have said it at the convention or something. No, it was a burglar who wrote a letter to the Supreme Court and says, excuse me, this doesn't seem right. And even now, I'm not sure whether he did it or not. In our distinguished panel, we'll say that's irrelevant, but he might have done it. It was a 2-bit burglary. I won't go there. All right. So there are about 10 cases in the United States at the present time that hold a civil right to counsel. A couple of them are at the top of these various states in the Supreme Court of a couple of states. The others are intermediate courts. Some of them involve a sort of semi-criminal civil. Lassiter is the key case. None of the judges that seem to be passing on it seem to want to read Lassiter. There's 4 votes that says there's no right to counsel in a civil case. The only way they got the 5th vote was Berger, who wrote an opinion which said, I will join this opinion only because it wouldn't have made any difference. Lassiter was the worst mother in the history of the world. She had given up the kid, she was in jail, she didn't care, then all of a sudden she cared. And so Berger said, you know, it wouldn't, but you have to go case by case. That's the Lassiter case. In California, it's due process that's the heart of it. And we have written draft briefs on the subject. We had a mock argument with 2 former members of the California Supreme Court of different philosophies, and then we watched them deliberate. You know, that's the age in which we live. We do these mock things. It was very interesting. It was very interesting. Is it possible to do it? Yes. The Golden Gate Bridge, when it was constructed, everybody says it's a mistake. The pyramid that was built in San Francisco, that's a mistake. It's an eyesore. It's terrible. That's the way we are as humans, all right? To play basketball, it's a mistake, all right? People will get hurt. I mean, we're going to have crowds. They'll catch each other's colds. I mean, my God. And yet I'm going this afternoon, you know. So it's the impulse to overcome, first of all, to hear the rational objections, and then try to meet them, but the impulse to say, you know, the time has come.
You see, you got to have a sense of humor to be a great trial lawyer. Now we're going to answer some questions from law students. But you have to come to the microphone so we can hear you. And while you're lining up you got to come to the microphone. I want to tell Jim that over 60% of our family law cases are proper person.
Yeah.
What we've established when we see a good issue on appeal, we get a pro bono attorney to handle it and file briefs.
That's
and everything.
great.
And that's Nevada's court, because I wanted to outdo Kentucky a little bit. Your first question to our panel.
Yes, hi, I'm Nick Tosca from UNC Chapel Hill. I had a follow-up question for Mr. Brosnahan about Civil Gideon. I like the comparison to the Golden Gate Bridge. We're from North Carolina, never been to this area before. We went to go see the Golden Gate Bridge yesterday. And we then read that 30 people died in the construction of it.
Yeah.
And I think that is an appropriate metaphor, because I think there's going to have to be a lot of sacrifice, and there's going to have to be a lot of things that get done in order for us to make that transition to Civil Gideon. But the question that I had for you is, I'm wondering, it's a 2-part question really. What does your Civil Gideon look like? Is it just for defendants? Is it just for who gets to pick the cases, et cetera? And I guess a question within that is, how do you address the other side's arguments that it's going to cost too much money, there's not going to be any screening of cases, et cetera? So how do you see the Civil Gideon?
Okay, 2 answers. The first is, what does the case look like in California that says there is a right? There's already the Sousa case that was just before Lassiter that said there is a civil right. There's all kinds of arguments out there that California has a right to civil counsel. Nobody quite focused on it. But what does the case look like? And then what is the plan? What does the case look like? It might be a mother in Superior Court in Sacramento County who had shared custody of her 14-year-old daughter, and then she had an accident and she's disabled. She has some mental difficulties, but she functions. And she's certified as disabled by the Social Security group. She had no lawyer, and her husband has a lawyer. and she goes to court and she loses total custody. Not because it's in the dependency court where those things usually happen, but because this judge says no relationship. In California, you'll be glad to know, your relationship with your child is a fundamental right. So it might look like that. And there we are, and maybe we're in the Supreme Court. And maybe there are 4 votes that think a mother should not lose total custody of her child with no lawyer when the husband has a lawyer. That's the case. The plan, the closest I have is the ABA resolution of 2006, which talks about lawyers in fundamental rights. One of the arguments against it is interesting, and that is if there's a right to counsel, it must be a right to competent counsel, just like criminals. So there'll be all kinds of litigation about whether to which my answer, we being here at Stanford in a scholarly place, my answer is, duh. Excuse me, you got a problem with competent counsel? I mean, that's a problem. So I could do better than that, but that's, I mean, you get the idea. So those are the 2 answers.
Thank you.
Young lady.
Jessica Jackson McLean. I'm from Indiana University, and I had a question for Mr. Adachi. I was wondering if you could tell us a little bit about your Children of Incarcerated Parents program that your office does.
Yeah, well, thank you for the question. It's something I'm not often asked about. We don't realize that every night when we go to sleep, there are 2.1 million children in this country who go to sleep without one parent because they're in custody. We over-incarcerate more people than any third world country. I think that the number that I heard recently is that I think 1 out of every 10 people is under some kind of criminal law or justice supervision, and 1 out of 100 is actually incarcerated. The Children of Incarcerated Parents program was a pilot program that we started 10 years ago. We wrote a grant to a private foundation, and the hope is that we would be able to provide services to parents in appropriate cases who are in custody and wanted to maintain a relationship with their child. I can remember a case that I handled. It was a probation revocation. My client was on probation, was charged with possessing a small amount of cocaine, and the police had done a probation search on his house and found the drugs. He was a single father, had a full-time job working at a bank, and the judge decided to take him into custody. And even though the probation department had recommended no jail time. And I never forget, as he was being hauled off to the jail, he threw his keys at me and said, "Hey, will you pick up my kids from school?" And it wasn't even an afterthought. I talked to the judge about it, and he said, "Well, don't they have orphanages, orphanages for that?" And that's what he said to me. And there was just very little awareness, by the bench of the impact that incarceration has on children. And so what we began looking at is not only providing direct services, that is, things like visitation, making sure that they had visitation in the jails, providing linkages to lawyers who would represent in custody matters if you had an outstanding custody matter, because the first thing they'll do is they'll take your child. But we also began working with the police department and probation department to ensure that arrests were not made in the presence of children, where it was because, again, you don't know the traumatic effect that does have. And there's a second, group of people who are affected always by what happens in the criminal justice system. So yeah, we've had this program for 10 years now. We have a full-time social worker who does this work. And obviously it's not appropriate in every case. If the child's a victim or if there's some circumstance that would argue against it, then we don't provide the service. But it has been something that in our office has made a huge difference, because if you're able to address the client's immediate needs, then they trust you, when it comes to dealing with their legal needs. There are programs at I think one of the public schools. It's a concept that's slowly getting out there. There's a couple of really good books, one by Nell Bernstein about children of incarcerated parents, and it's a growing movement. So thank you for your question.
Thank you. Next question.
Hi, Joe Bosdick from University of Illinois. My question is for Jeff and also for Elizabeth. You spoke about the case limit controls that you've implemented. I was wondering how you balance them with that other Sixth Amendment right, the right to a speedy trial, especially for clients who are already incarcerated. And I'm thinking in particular about situations like in Boyer v. Louisiana, which is before the Supreme Court now, where the defendant was in jail for 6 years while he was waiting for funding for his capital defense. So I was wondering if you could speak to how you balance those two competing interests.
You know, my response is sort of in this sense that, you know, if there's a responsibility to provide counsel and a responsibility, I mean, a constitutional right under the Sixth Amendment to provide effective assistance of counsel, then it's simply not tolerable, not only just not to have the lawyers available, but to allow caseloads which make it impossible for the lawyers to do what they need to do and for a client to have to sit in jail for 6 years awaiting trial. I mean, there are some different issues here. In capital cases, the preparation time is not comparable to what it is to try a misdemeanor case, for example. But you can't simply cut the caseloads without providing more lawyers and more skilled lawyers. And you know, so it seems to me that you can't address the issue of speedy trial in a vacuum by simply saying that the client has that right. The question is how you're going to remedy that right. And the remedy to that right is to do something about funding for public defenders, for appointed counsel, both in terms of numbers and in terms of quality. And that's, you know, the court doesn't, so grappling with this issue in a holistic way is the only way to begin to answer it. And that's something the court has a hard time with.
I just wanted to say that before Jeff was the public defender, I'm thinking, Jeff, it might have been the late 70s, two of us on behalf of the bar brought a lawsuit that the public defender's office in San Francisco was denying due process to all of its clients. And we had evidence. We had a trial that lasted in front of Wallenberg for about a week. Right. And they had like 2 telephones at that time or something, and they had no yellow pads, and it was an eye-opening thing. The idea was to get more funding.
When I started in the public defender, in the infamous Solano County, which is every bit the way it was described by Jim, there used to be something called a Ligda motion, and so there were some good things, not about the county, but about the public defender office, and Paul Ligda, who was then the public defender. And it started in juvenile, and I had some insane caseload, like 200. I mean, I was a brand new lawyer and had 200 cases, and I just, you know, I went to him and I said, I absolutely can't do this. And he said, no problem. And we marched ourselves into court and declared a case overload. And it was something he did routinely when lawyers were, you know, at a point where they could not manage their cases. So it also, you know, it also requires, I have to say this, courage and ethics on the part of the public defender office, because one of the difficulties we have with this whole question of independence and where is the money coming from, where are the contracts coming from, depending on what the financial arrangement is, public defenders, appointed counsel, et cetera, are sometimes loath to go in and say, we have a client sitting in jail for 6 years, because it means that they're not going to get the next contract.
Yeah, and that's what we do. We declare unavailability. I've done that twice, and in both instances because they cut our budget. And what happens to those cases, people are still entitled to representation, so they'll go to the private bar. And it ends up costing usually the county more. Where it's particularly problemsome, though, is where you have a private contract lawyers who essentially agree to represent everybody who's accused of a crime in this county for, you know, $50 a case, and particularly flat rate attorneys who will accept a case and they'll get, you know, $200 in a misdemeanor case regardless of whether you go to trial. Well, you can imagine how many of those cases go to trial. Very few. And the problem, I think, that a lot of appointed, I'm elected, so the only way I get fired is if I'm not reelected. But for appointed attorneys, many of them are, quite frankly, afraid to declare unavailability because they'll lose their jobs. And so you don't have the exercise of that obligation. It really is an ethical obligation when your attorneys are overloaded.
to declare unavailability. And it really has to be part of the accepted practice of the public defender to look at your caseload from time to time and figure out what cases you simply can't provide that level of representation. It's not only the attorneys. You might not have enough investigative support. You might not have enough expert witness funding. All those things factor in.
There's another issue, because we're working on caseload standards in Nevada, and that's a dictionary as defining what is the case. And when you include DAs, as I have to do, and other judges, and people that are think a little differently than I do on this issue, it's very difficult sometimes to define a case where it is a reduction from a felony to a misdemeanor, or to we have a gross misdemeanor too, which is a jail time thing. But it's not an easy, it's a tough question what you've asked, because you have to go before a judge and have an evidentiary hearing as to what your caseload is. And it's a real problem throughout this country. There's no doubt that the caseloads.
Let me also just mention, Steve mentioned this last night, and Jeff did as well, this whole idea of flat fee contracts. I mean, in California, in the counties that impose the death penalty most frequently, starting with Los Angeles County, which, by the way, you know, last year issued more death sentences than Houston County, which you heard about last night. The norm is now these flat fee contracts, and they're not just flat fee contracts, they're flat fee low bid contracts. So that means when the lawyer's name comes up and he or she bids X amount to do the case, and you have to make this bid within days of the case coming on to the calendar. So you can imagine how little you know about what it's going to cost to do a capital case within a week of the time the client is arraigned. And if your bid is rejected as being too high, you have the option of decreasing your bid, or your name moving down on the list and the case going to the next lawyer. Well, the next lawyer knows, if he's gotten the case, that the reason he's getting it is that your bid was rejected, so what do you think he does? And this is, and in these same contracts, which, as I said, are now ubiquitous, there is no right to second counsel. Even in the state of Alabama, which we mock all the time with good reason, you have a right to 2 lawyers.
Thank you.
Last question from our audience.
Thank you. Good morning. Sam Eisenberg. I'm from Minnesota. We talked a lot about the courts. Professor Summerall, you said Justice Alito doesn't care about the ABA guidelines. California Supreme Court doesn't care about the ABA guidelines, but I would think that the ABA should care about their guidelines. And I was wondering if anyone could comment on the role of the bar associations in all of this. And I guess I naively thought that you might be disbarred or at least held in contempt for being drunk during trial or sleeping during trial. And it seems, are any of the bar associations better at that, or what's the angle through the bar associations?
May I comment on that? Because I did want to tell you about the Bar Association of San Francisco. My daughter practiced law in Minnesota, but testified. It had nothing to do with the rest of you, so you can just phase out. She testified this week. She's a lawyer in up north, and on child abuse and the question of it. So I just thought I'd throw that in. The Bar Association of San Francisco is composed of farsighted people who would rather be controversial than not. We have a committee called the Justice Gap Committee, and I'm co-chair. We have a slogan. Our slogan is, we don't think, we just do. And we adhere to it. In other words, the only thing we discuss is what we might do right now. So, for example, there should be a rule in California that any judge can appoint a lawyer, a volunteer lawyer, in any matter of any kind. There should be such a rule. There is such a federal statute, whether it's used much or not. So we have that kind of thing. But secondly, we went to the city and we asked them to declare themselves to be the first right to counsel city in the United States. And because of the tremendous work of Supervisor David Chu, who's a lawyer, and the Finance Committee, composed of all lawyers and practicing lawyers, San Francisco is now the first right to counsel city in the United States. We're trying to get a second city, a third city, and so forth and so on. So the Bar Association, the ABA is very good on right to counsel. They have John Pollock, who spends all day, every day, working with lawyers throughout the United States on the issue. So that's really it. I want to leave you with this question, which I learned in 1963 as part of the NAACP Housing Committee in San Francisco. At the time, 2/3 of the housing in San Francisco was not available to people of color. We forget this, and we should. There's no reason to dwell on it. But what I learned, the question, if you're a law student and then you're going to be a young lawyer, when you want to reform something and somebody says it's not a good time, ask them when would be a good time. What I like to do is, it's not a good time to do right to counsel. So I like to say, I hear you, I understand. How about next Thursday? How about 2 weeks from Friday? Is that better? No, that's not good. Okay, then what you're really saying is that all the mothers and all the people that are losing their houses and all the people that are getting their credit ratings whacked and all of that, all those people are going to go, what? Would you like another 5 years? Would you like another 10 years of that? Well, how about 20? What is your plan? Do you have a plan? Do you have a substitute plan? Anyway, okay.
Let me answer your question in this way. When lawyers are disciplined, it's by the state bar. So it isn't going to be by the Bar Association. So it's not for lack of, and you know, let me also say, it's not as though I want to put the ABA on a pedestal, although having directed the State
Bar Association as well.
Yeah, well, the state, but it's in California, for example, if a lawyer is going to be disciplined because he or she has provided ineffective assistance of counsel, that discipline comes from the California Supreme Court. So. The short answer to your question is that in California, although a number of lawyers have been found to have provided ineffective assistance of counsel, no lawyer has ever lost his or her bar card as a result. However, I think there's an equally important point. No prosecutor in a capital case who's withheld exculpatory evidence or engaged in other forms of prosecutorial misconduct has been disciplined. So it's, you know, there's a huge, huge problem. And as Steve was saying last night, you know, at the end of the day, is it the discipline that we care about more, or is it the fact that don't appoint the lawyer anymore? Don't let the lawyers, you know, don't let that lawyer touch that kind of case anymore. I think you raise a very good point. But you know, to me, it's kind of on the periphery of the bigger question.
Let's, go ahead.
And I just wanted to say, in terms of the point of standards or the purpose, at least in the case of Padilla v. Kentucky, the court specifically looked to the standards, you know, to find the attorney incompetent. They specifically set the Strickland Prong 1 standards ineffectiveness based on ABA, NLADA standards, you know, all the norms, all the trainings we had been doing. And so it's still useful to determine, you know, what are the norms, when is someone incompetent, when are they not providing effective assistance of counsel. And so that, you know, the standards are always important for that.
We could have a whole panel discussion on Strickland, by the way. I want to thank Jim and Elizabeth and Jeff and Sejal.